Welcome to the kickoff of our H1B Cap season. We're very excited to get going. As we all know, H1B Cap season comes quicker than we think. And with the registration and all the different ways that have changed in the last few years, it becomes quicker and quicker. And what used to be something that started in April and getting ready for April, now we're getting ready in March. So things are getting quicker and quicker. And we're getting going quicker and quicker. We want to make sure we're ready to go and make sure that it goes as smooth as possible. So James, can you please change the next slide? So as we always start off with a legal disclaimer, we are lawyers after all. So everything we do say is for informational purposes. It's not legal advice for a specific case. Any specific questions, feel free to reach out to WR legal team. We're happy to answer any specific questions. This is for informational purposes, just to get us into the mood, to get us going, to know what we need to know what questions that we need to know, and just most importantly, to get an idea and to get started on the application. So we all know that immigration is certainly very, very complicated. Every fact pattern is its own fact pattern, and we want to just make sure that we respect that, and we can therefore go on to the next slide. So a little bit about the firm. Most of you probably know somewhat about our firm. We are one of the legal firms that deal with immigration. Certainly, you can see some of our accolades for what we consider to be a top legal firm, immigration law firm. I would say more importantly is that the people in the firm have a sense of mission. We're not really only about getting the cases filed and going. That's also very important, but we care about every single client, every single company, and we want to make sure everything goes smoothly as possible on that basis as well. So next slide. And part of our mission and the part of the way we do that is through our software, and we've tried to develop our own software. It's in-house software. It's not a general software for immigration law firms. We've done that. We've developed our own software in order to really to encapsulate what we need. It's based on what our clients want, and it's based on using technology and triggering and elevating technology to help us and to help you to run your immigration systems, to run your immigration cases, and make it easier for everybody, quicker, more efficient, and to take what can be a very tough, unforgiving process and try to make it as efficient and as easy and as quick as possible and as painless as possible. So coming to the presenters, my esteemed colleague and partner, Miki, is going to be handling this with me. We're going to be going through the H-1B process a little bit, mainly the kickoff of the H-1B process. We're going to be speaking about the registration system and some of the basic H-1B concepts, so that we're all ready for H-1B season. My name is Cliff Rosenthal. I'm one of the other partners in our law firm. I have over 20 years of experience in immigration, and with Miki, who also has many years of experience, we're happy to help you in any way we can. A major part of this presentation is really to answer your questions. We're going to have a question and answer session at the end. And that will allow us to answer any questions that you may have, any questions, any concerns, anything that might be bothering you, or just that you might be even curious about. We're happy to deal with those, and we're going to focus on that. We're going to focus that on the end, but we're going to start off with just the basic building blocks of the H-1B and just go through the basic registration process in order to achieve our immigration and our H-1B goals. So with that, we're going to start off with the H-1B, the H-1B quota. The H-1B, James, you can go to the next slide. So the H-1B cap, or the H-1B quota, is really based on a quota for H-1Bs. And there's a fiscal year, and that fiscal year starts in October every year, and it goes on until all the H-1B quota numbers have been reached. But before we even get to the quota and the lottery and the things that, the issues that bother or that concern most employers, I just want to go through what we call the major building blocks, the basis of an H-1B, because what we want to get early and we want to get going and we want to get all our complicated registrations done. But if we don't have the basic case, we don't have the basic building blocks for an H-1B, we're going to think that we all way away and we're great and we even get selected in the H-1B lottery, and then we realize we haven't met the basic requirements for an H-1B. So when we get to the lottery, we're going to see really what is the lottery. If you win the lottery, you don't win the H-1B, you don't get the work visa. The lottery is really just the privilege of filing an H-1B application. So part of what we want to do is we want to make sure that we do have all those H-1B building blocks, all the components necessary for an H-1B, so that when we are selected, we are ready. So there are three basic components, and the three basic components are job, employee, and wage. So when it comes to the job, not every job is going to qualify for an H-1B. So it has to be what we call a specialty occupation. For lack of a technical definition, it really has to be professional enough. And what do we call professional enough? Professional enough means that this specific position requires at least a bachelor's degree in a specific field. So basic examples, if you're a lawyer, if you're a doctor, then those are very clear. You cannot become a lawyer or doctor without at least a bachelor's degree in a special in a specific field, law or medicine. Might require even a higher degree, but at least at a minimum a bachelor's degree. If, for instance, you're a taxi driver, you might have a PhD in biophysics, but the actual position of taxi driver does not require a bachelor's degree in a specific field. So those are kind of the two extremes, and then you've got everything in the middle. You've got, for instance, software engineers, and you've got graphic designers and accountants, and certain positions where it could be usual to have bachelor's degree or common or different degrees of commonality of a specific bachelor's degree, but it's not required per se by law, for instance. So, for instance, a software engineer, many software engineers could obtain a position as a software engineer by learning on the job without having done any formal education, although most or many software engineers require a bachelor's degree. So in that case, we have to look into what the position at a particular company requires. So there are different degrees of showing what the bachelor's degree requirement, but the major requirement is that this position requires at least a specific bachelor's, and that's as opposed to a general bachelor's in the arts. You must have a specific bachelor's, such for a software engineer, software engineering degree, or computer science degree. So that's the one aspect, job. The second aspect is employee. So just as the job requires that position, so too, clearly the foreign national, the employee must also have that requirement. So for instance, if the position requires a bachelor's degree in software engineering, then certainly the foreign national must have it, or must have some sort of equivalent. An equivalent doesn't have to necessarily be a degree. It could even be a combination of education and experience, if we can get that evaluated to be the equal of the bachelor's degree in the field. And then the third part is the wage, and for many that's very, very important, is that the government, the Department of Labor, puts down a minimum wage for this position, and you have to pay at least higher than this minimum wage. So the more requirements you ask, the higher that wage will be. So in general, when we're looking at H-1B, we're looking to see, do all these three things match together? Do they all come together so that we can have a qualified H-1B? So the job must require a bachelor's degree in a specific field. The employee must have that specific bachelor's or the equivalent of it, and then the wage must also be appropriate to that particular position, and that's based also on location as well. We can go on to the next slide. Okay, so we touched on this a little bit before. This is the H-1B lottery, and the H-1B lottery is essentially based on an H-1B quota or cap. So there are only 65,000, and these are new H-1B visas. Some H-1Bs are exempt from this quota, universities, extensions, etc. But essentially, there's 65,000 for the entire country. And there's actually a carve out of 6,800 that are used for special H-1Bs for those with Chilean or Singaporean nationality. So it's even less, 65,000 for the entire year, for the entire country. And again, these are new H-1Bs, mainly for private employment. Then there's an extra additional 20,000 that are reserved for those with advanced degrees, master's degrees or high advanced degrees from the US. They have to be US master's degrees or advanced degrees. So essentially 85,000 minus 6,800 for the Chilean and Singaporean nationals is your quota for the year. So it's not a lot per, it's not a lot of new applications per year. So what happens is if the demand for the H-1B exceeds the number of visas available, and that's happened in the last few years. In the old days, during the Clinton administration, they temporarily upped it to 180,000. And during that time, it was very seldom that the quota was ever reached. But that law sunset and went back down to 65,000, and then 20,000 for the masters was added. But if that, with that small cap and the demand, I would say, especially for tech workers, has increased incredibly. Certainly, since the Clinton administration, is what happens is that we're always in a situation where the number of visas are required. The demand for H-1B visas are much lower than the amount that are available. That's 65,000 plus the 20,000, and because of that, they have a random computer-generated lottery to select these cases. So it's all done by random. It's now done by a lottery system that's done in a pre-registration online system, which makes it a little bit easier for us. Before the system, everybody would send all their packages to immigration, and we were told that hundreds of thousands of FedEx packages would arrive at immigration, causing big supply chain problems. To use the analogy that we're so used to today. That was, it's certainly a great problem, in terms of the demand outweighing the supply. And the selection rates for last year, so fiscal year FY is fiscal year 2022. So as mentioned at the beginning, the fiscal year of immigration goes from October to October. So last year is 2022. This coming year will be fiscal year 2023. So last year, the acceptance rate was 28%, and the year before was 45%. So we don't really know too much. It's probably a little bit higher because there were extra selections afterwards. But the point of the matter is that demand always outpaces supply in terms of these visas, and the selection rate is relatively low. So it's certainly important to get in and to make sure that it's done correctly.
Great. So I will talk about how the registration system works. So we expect that the system will be similar to the last couple of years. And in the previous years, the government opened the registration system in early March for about 2 weeks. And for a few days before that, the employers can go in, and if they do not already have an account, they can go and set that up. If you have your WR team work with you on the registration, we can certainly help you do that and help you navigate. And during the window for the registration period, the company can enter the information for the employees that they want to sponsor. The registration itself really requires only basic information, the employee's name and their date of birth, country of birth. But we do recommend having our firm handle the registration, because we can then step in if you have any issues navigating through the system, or if there are any technical glitches on USCIS's website, we can get you the information timely based on the alerts that we receive. And then also we can review the registration information to make sure you're not missing anybody, and also, most importantly, to make sure that there are no duplicate entries. This is really critical because one company registering the same individual twice would lead to an automatic disqualification. So we definitely want you to avoid that. And then at the close of the registration time period, the government will run the lottery and will electronically notify employers and their attorneys of the cases that were selected. So once the registration has run, you'll get an email, and on the portal, it'll show submitted. What used to be shown as submitted, that'll change to selected. And then you can download the notice, and then we'll be ready to file the petition from there. So in the past 2 years, we have received the notification of the selection at the end of March, I think generally the 29th, 30th, the 31st. And then the filing window begins April 1st. And you have a 90-day window to file the petitions with the USCIS. James, if you can go to the next slide. Thanks. So if your employee is selected, what do we do next? The next step is to prepare the petition filing. And, as I mentioned, there's a 90-day window, and you can file the petition anytime during that window. There are a couple of scenarios in which we would urge you to file early in the window to give your employees ample time to get the documentation they might need. For example, if they are in F1 status and their work authorization might expire in early April or May, the employee will need to get what's called cap gap protection that Cliff will talk about a little bit later. And many of our clients do have us prepare the labor condition application. That's the first step in the H-1B process before, the April 1st timeline, so that at the outset of the case initiation, we can vet the prevailing wage for you, so you can get ahead of any issues. And you can, plan ahead for any prevailing wage obligations that come up by October 1st. Then with the certified LCA, we will collect any updated information from you and the employees, if any information has changed, and then we'll file the petition with the USCIS. And then, of course, we'll keep you updated timely once the case has been accepted for processing, so that's when the receipt notice would be issued. And then if there's any request for evidence, and then ultimately the decision. So at this point, and before I hand off the floor to Cliff, we don't know yet if premium processing will be available for this coming fiscal year lottery. In previous years, USCIS has on occasion suspended premium processing. That is not yet confirmed if premium processing, that 2-week expedited service, will be available for this coming cap season, but we will keep you apprised.
Yeah, I think we're hoping that it will be. Now that immigration staggers the H-1B filing, you get that 90-day window for everybody. I'm hoping that it's not going to be too much, that immigration will, too many filings at the same time, that immigration will be able to honor the premium processing. But as Miki mentioned, we're just waiting to see and get confirmation on that. Okay, to go on to the next part, there are 2 ways to file an application. So one is called change of status, which means that the employee status, the H-1B status, is changed. So usually from an F1, but it can be other status as well. It's changed from an existing status to another status. In this case, it'll be H-1B. And it's all done in the United States, and it all happens automatically as soon as the date which you asked the change of status to be triggered is reached, and automatically on that date the H-1B status is completed, and then it's done. The alternative is what we call consular notification or consular processing. Instead of the application being automatically triggered or activated by a certain date reaching where the application would be started, it's triggered by something else, by actually going to a consulate abroad, getting an H-1B visa stamped or inserted in your passport, and then returning to the United States and entering in order to activate that H-1B. So you might be wondering why you'd possibly want to do this over, just having your status automatically changed in the United States. So the real reason is that if a few strategic reasons to do that. The main reason is if the person's abroad, they're not in the United States, then they have no status to change from. They cannot do a change of status. They have to do it abroad. The other main reason is if the person has F1 status or some status that's going to expire before the October 1st, which is the first date that H-1Bs can be approved and be started. So if that status expires before October the 1st for some status, and we're going to see an exception in a minute for F1s. But generally, if it's not an F1 visa, if the person's not on F1 status, if their status will expire before October the 1st, then we cannot do a change of status. We have to go consular notification. Also, while the application, if any change of status is pending, that change of status will actually be abandoned if the person leaves the United States. So if they leave the United States, they will lose the change of status. So in that case, if they need to travel while it's pending, then at that point they would have to do the consular notification. Next slide. So I just want to speak about a very common situation and a very important situation, and it is an exception to what I mentioned before about having status till October the 1st in order to affect a change of status to H-1B. So what typically happens with most students is that they're on an F1 visa, they're at school, and at some point that they graduate or finish school, and then they get something called OPT, and OPT is called optional practical training. Essentially, it's a 1-year training visa or training or work authorization or work permit in order to work and train and learn and intern in the person's field. And if that person's in a STEM field, that can be extended under certain circumstances for another 2 years. So what happens if that OPT, that training work authorization, expires after April 1st? And what's important about April 1st is that's the first time, as Miki mentioned, you can start filing H-1Bs. What happens if that training visa expires after April 1st? The person, however, is selected in H-1B, but that H-1B, as we mentioned, will only be triggered, can only start because the fiscal year can only start on October 1st. So what happens between April 1st and October 1st, or more succinctly, what happens between the time that OPT expires and October 1st when that H-1B triggers? So the government instituted something called Cap Gap. So what happens is if you file an application, and not just selected in the lottery, but if you file an application before that F1 OPT expires, then they will close the gap. In other words, the gap between when that F1 OPT work authorization expires until October 1st, when that H-1B starts, you'll have continued work authorization for that. So there's certain things that the person has to do. They have to get their I-20, which is their main student document, updated and endorsed for this. But essentially, this will allow the person whose OPT expires to continue working until October 1st.
So great. So what happens if an employee is not selected? What does that mean? I just want to make sure that you all are aware that when someone's not selected in the lottery, it doesn't mean it's a denial or a refusal. It just means that the case was not selected for the privilege of filing, like was mentioned earlier. And it doesn't have any impact on eligibility for future immigration matters. So you can opt to enter that same employee in a future lottery in the next year. For anybody for whom this was the last chance to get a CAP H-1B without a break in their work authorization, for example, if you have an employee whose STEM is going to expire and, it's going to expire before the next lottery, that employee would need an alternative plan. We can work with you to figure out what's the best alternative strategy. And we have a webinar coming up next Tuesday, the 30th, that will discuss some of the options, and they will cover some options like, people who are citizens of a country that have bilateral treaties that have special visa categories, if they're from Canada or Australia, Singapore, Chile. So those are some options. Additional options might be the O1 visa for individuals with extraordinary ability or L1s. Some people might have the option of working as a dependent spouse of somebody who has a work visa that allows for dependent spouses to work. And then perhaps, it's a relocation to the company's entity abroad, and we can help with non-US options as well. We have a team that is dedicated to exploring those options. And then in some cases, it might mean that people can jump right into a green card if that's permitted. So please do attend our session next week. And so, before we get to the Q&A, I wanted to go over some of the takeaways for next steps for all of you company contacts. And so now is really the time to look at your employee population and figure out who you want to sponsor, who's not already in H1 status. So I would definitely encourage you to enter into the lottery anyone who's in F1 status, even if they're really early in their OPT period, because like Cliff mentioned, selection rates are quite low in recent years. And so the earlier that you can get them into the lottery, the more chances they will have. And then by January, we would like to be working with you to start the case, start collecting from the employees their information, and then job details from you so that we can make sure we're discussing all of the people who qualify for an H1. Maybe the H1 is not the best option for them, depending on their situation or their credentials or the job itself. And so we want to get ahead of any issues by helping you to plan ahead. And then by February, we want to work with you to put together that list, that final list of registrations, and make sure that all of the information that we need is with our team. We'll prepare the registrations for your final review before March, and then audit the list to make sure that all the ducks are in a row. And then one important note too is that if you are a company that has not previously filed H1s or labor condition applications before, please do contact our team as soon as possible so that we can get you registered in the system for the Department of Labor. That's separate from the USCIS's registration, and it does take several weeks for the Department of Labor to set employers up. So please do make sure to reach out if that is the case for your company.
I just wanted to echo what Miki was saying about starting early. The selection rates are low, so any employee that you have that you're in doubt, maybe this year, maybe they have 2 years left on their OPT, their STEM OPT, maybe they're 1 year, maybe you're not sure. Whether when you're in doubt, you should definitely consider doing it as early as possible because the selection rates are low. And then, as Miki mentioned, the registration process can be a little bit unforgiving. So to get all your ducks in a row, get all your applicants and their details and everything ready to file, as soon as possible, to make sure that everything is ready for the time that the lottery actually starts is critical.
So we are at 2:30, but James, can we hold the session open for a little while longer for questions?
Sure, Miki, absolutely. We have a question coming in here. Let's see. So can my employee be counted for the master's cap if they are currently in the program, but they won't have a diploma by April 1st?
I can take that one. So if the employee has completed all of the requirements for the master's, but they haven't received their diploma or they haven't quite graduated, but can produce documentation from their school that they have completed all of the requirements, then we can enter them into the master's cap. And keep in mind that the master's cap is only for people graduating from US master's degree programs or higher.
Right. So it's really, as Miki said, it's really the registration process is really that. It's just a registration process. The general rules of immigration and of filing applications is that you have to have the requirements, meet the requirements of any application. This goes through not only H-1Bs or visas. You have to meet the requirements for a particular application at the time of filing. And time of filing is going to be considered the time that you selected, and then you send in the application pursuant to that selection and not necessarily the time of registration.
Great. We have a few more questions and they're still coming in. Miki and Cliff, are you okay to go over to dive through these?
Yes, absolutely.
Yes, definitely.
Okay, great. So first up, how do we figure out what the wage requirement is?
Okay. Go ahead, Miki.
I was just going to say that the Department of Labor has a database called the OFLC database, wage database, where we can look at the sort of menu of occupational options, and it breaks down into wage levels depending on the requirements for the position. And so that's a publicly available website that we can send through chat. But we can obviously the WR immigration team can certainly help you to determine what the right occupational code is and what the wage is, because a lot of jobs fall in between 2 or 3 occupational classifications, and there's considerable strategy that goes into figuring out what's the best for H-1B purposes. So we're happy to help you with that. And then if the Department of Labor's wage is too high, there's also the option of working with a private wage survey to see if there's a lower wage that works and still meets the requirements of the H-1B. Cliff, do you have anything to add?
Yeah, I'll just add one thing is that the prevailing wage is one part of the equation. And then regardless of what that prevailing wage is, the wage that has to be paid to the person would have to be higher than what's called the actual wage. So we'd also look at what similar situated employees at the company, in other words, those employees in the same position or similar position at a similar level, years of experience, skills, etc. What did they earn? Because the main purpose of this H-1B wage is to make sure that foreign workers aren't coming in to undercut US workers. So they want to make sure that there's a threshold that even if the company is paying their workers very, very low, that US workers are paid above that. But also they want to make sure that you're not actually undercutting the workers at the particular, and this is all done by location at the particular location as well. So it's what's called the higher of the prevailing and the actual wage. And that would be the minimum wage. So even if the prevailing wage is relatively low, you couldn't go below what others are being paid in that position by that particular employer in that particular location.
Great. Okay. Maybe, Miki, we'll start with you on this one. What are the chances of getting selected in the master's cap section as compared to the general H-1B pool? We have 2 employees that have received their master's in the US this year and would qualify.
Yeah, I think it's hard to give sort of statistics because it's based on demand against supply. So we don't really know what the demand will look like. But in general, the master's cap has better chances of success, certainly, than the general pool. I don't know, Cliff, do you have stats in your head?
I don't think they passed out the stats this year, but I just want to mention something. And additionally, just in case there's any confusion, is that you don't have to choose between the master's cap and the regular cap. So what happens is if you enter and the person has a master's degree, US master's, and they're automatically entered in both caps, so to speak. In the US and during the lottery, they will first look at the regular cap, and then if the person is not selected in the regular cap and the person has a master's, then they'll be automatically put into the master's cap in order to get into that lottery as well. So you do have, as Miki said, definitely, the master's is, if your person has a master's, you have a much higher level of qualifying just because you have 2 bites of the cherry. You go in both caps. But other than that, I don't think that they published results how it was passed out this year.
Okay. Great. Well, we have several questions still outstanding. Maybe we do one more and invite people to email for further answers. What do you think, guys?
I think all of our questioners are outstanding.
Okay, good. I like the pun. So, Cliff, why don't we start with you on this one? Can two different companies register in the lottery for the same applicant?
Okay, so that's an excellent question. So as Miki mentioned, certainly one company, and that's usually done by FEIN number. So one company cannot apply for duplicate applications. They cannot apply for more than H-1B for one person, even if the position is completely different. But if you have different companies and they are related, and related is very technically described. It doesn't necessarily mean they're part of the same group. They could even be, and there was a case in 2018 that dealt with this, a case that said that even a company where you had a company who was what we'll call the actual employer, for lack of a better term, and another company who was providing the job it was a type of a job shop, or contractor was providing contract work. That's a better way of putting it. They said that even though there was no real relationship between the two companies, as long as it was the same position, it was the same job opportunity, then you couldn't do that as well. So just to summarize, what that means is if you have two companies and they are related to each other, there may be, they could be contractor company, with a very, very loose relationship, or they could be part of the same corporate group. If the position is a different position, then you can apply for more than one for the same applicant more than once. If it's really the same job, then you wouldn't be able to. It would be considered a duplicate registration.
Okay, well, we still have several, and I'm just going through in the order that we received them, and I know we're running long. How about one more, and then we'll go ahead and bring this to a close. Miki, could I direct this one to you if possible? I will be in India in the month of January and will be back to the US in the month of February. Does this affect the application process while you prepare us for the document collection?
No, international travel during that time frame prior to filing of the H1 petition would not have an impact in terms of, the two strategies that Cliff mentioned, change of status versus consular notification. In the actual petition, if you are fortunate to be selected in the lottery, then we would need to include the most recent I-94 as part of the petition package.
Great. Well, that one was so quick. There's one quick one that I see, and I thought maybe I'll throw it to either of you. Do I have to get a job before applying?
So it sounds like, well, go ahead, Cliff.
I was just going to say, the registration is an employer registration. So, you certainly have to have an employer on board who's going to register you. But I don't know of any rule that technically says that you actually have to have the job. It has to be signed. It has to be sealed. As long as certainly by the time that if you selected and you file that you have the job and all the details are ironed out. But it would imply that you get an employer on board to at least to apply for you, to register you. Otherwise, you cannot register. You cannot register. An individual cannot register by themselves.
Great. All right. How about Cliff? You could take us home.
Okay. So thank you very much. Again, we're very happy to kick off our H1B season. It was, comes up very quick, and we need to get going, and we're happy to go, happy to go forward and to help you with your H1Bs and to get going. We're excited again. And then join us next week, as Miki said. We've got another webinar basically on what to do if you're not selected in the lottery. So hopefully you're all going to be selected, and you will all enjoy this next webinar as a hypothetical. That would be my wish and blessing to everybody.
Thank you very much. Have a happy Thanksgiving all.